On the birthright citizenship front, a judge has renewed his order stopping Donald Trump's executive order altering birthright citizenship. But wait a minute. The Supreme Court said judges can't do nationwide injunctions anymore, right? Well, not really. Here's the Supreme Court case, Trump versus Casa. You always have to look at what the court actually holds, and here's what the order is in that case. The government's applications to partially stay the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. The lower courts shall move expeditiously to ensure that, with respect to each plaintiff, the injunctions comport with this rule and otherwise comply with principles of equity. That's exactly what the judge in this case has done, moving expeditiously to ensure that the injunctions are no broader than necessary to provide complete relief to each plaintiff with standing to sue. Enter District Court Judge Leo Sorokin. He quotes from the Casa case, saying ultimately the Supreme Court granted the, quote, applications to partially stay the preliminary injunctions, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. So he went through an analysis. He said the defendants have altogether failed to show that this alternative is workable or feasible and would avoid disrupting the process presently used by the plaintiffs to administer the relevant federal benefits programs. And he's talking about kind of using different standards for whether you're a citizen or not as to whether you're getting federal benefits or other benefits, and it's a total mess. After going through these various alternatives, the judge says this: despite the defendant's chosen path, the court, aided substantially by the plaintiff's meticulous factual and legal submissions, undertook the review required of it by Casa, the Supreme Court case, and considered anew whether its original order swept too broadly. After careful consideration of the law and the facts, the court answers that question in the negative. For the foregoing reasons, no workable, narrower alternative to the injunction issued originally would provide complete relief to the plaintiffs in this case. The court therefore declines to modify the injunction. So now it's back in place and can be appealed again. If you want to look at the whole order yourself, I found the link to it on The Hill's website. So go to thehill.com. It's one of the top stories, and you'll be able to find that case and read through the entire thing at your leisure.